Good morning, you're Jordan Thomas. And this is 24 DCCR 0487. Mr. Thomas is charged with sexual assault of a child, and 24 DCCR 2178 charged with aggravated assault with a deadly weapon. And what is the announcement?
Your Honor, we'd like to request just one reset. The reason being, he's received an offer that he wants to discuss with his family. There's some additional evidence that I need to subpoena, and then some additional evidence I need to go over with him.
Okay. All right, any issues?
No issue, Judge. He's got an offer.
All right, so Mr. Thomas, I'm going to reset your case so that Mr. Wilkerson can get all that information. He'll be out there to go over all of that with you, and we'll get an announcement at that next court date.
Yes, ma'am.
All right, you can go back with the bailiff.
Thank you, Your Honor.
Thank you.
Excuse?
Yes, sir. Appreciate that they don't want to have to do that work, but we need it in the case.
Yeah,
they've called me and told me.
tell them to call me.
Well, why don't we make a note, make me a note, and I'll make sure. And all right, you're Jamaldron Wilidge. Speak up.
Yes, ma'am.
All right, and Mr. Wilidge is on probation in 3 cases. We've got 18-2873 on probation for aggravated assault causing serious bodily injury, 18-28744 on probation for aggravated assault causing serious bodily injury, and then 18-30139 on probation for aggravated robbery. Mr. Lewis has filed a motion asking that I set bonds on Mr. Wilridge's cases. At this point, they're all no bonds. They are deferred probation, so typically he would be entitled unless I make certain other findings. And so, Mr. Lewis, you may proceed.
Yes,
Mr. Wilridge, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Okay, go ahead.
Judge, as far as Mr. Wilidge in regards to these bonds on the MPRPs, Judge, he is currently on bond for the new case. I don't think there's any additional pretrial conditions or anything on that bond yet. Of course, he's more than willing to comply with whatever pretrial conditions that the court deems is appropriate in the circumstances. He has been or will be in the home or care of one of his parents, either mother or father, during the course of this case. He has complied as well as he can or could be until the conditions of not only the case and bond, as the court is aware. As soon as it was made clear that he needed to turn himself in, he got himself in as soon as possible. He's not avoiding or running from the situation. He wants to try to get it worked out and resolved as soon as possible. At this time, the financial responsibility of that will be on his parents, as he is still seeking long-time, full-time employment. So we do ask that the court to consider that as well for that obligation. He is, like I said, more than willing to comply with whatever conditions that the court will put on him as far as any monitoring or drug patch or anything of that nature, for the court to feel comfortable while he's on bond. And of course, we'll work as fast as we can to try to come to some resolution to this situation, Judge. So we're just asking for bonds to be set that are reasonable from Mr. Wilidge and his family to be able to make while we get this worked out.
PSI, I feel like that's in my email. Huh? You sent me. What did you find? Who found that the other day when we were talking about this that I had.
Okay, let me,
I can look up my email right here. Hold on, because it would be from you, right?
correct.
Let me make sure I have everything in front of me. Well, if you did, it might be in one of the other ones. Hold on. You might have. Let me keep looking. Thank you. I don't know. It could have been in one and not the other.
I probably would have done the very first one, but I may not have, Judge.
What day was that? Thursday? that we were all
Friday.
It was Friday.
Oh, did you send it to my personal, maybe?
Do you need me to go get a copy?
I know I have hers. I was just gonna see if mine had my notes on it from back then. But,
It didn't, no ma'am, I didn't have an old one.
It didn't.
Jody had to send me.
Okay.
There were no notes on, but I didn't have an old one
okay,
or somebody.
There were multiple co-defendants in that underlying.
Yes.
Judge, and the court will recall from our discussion last week amongst all of us, that the age of the new case is due to it being incarcerated.
speak up, I'm sorry.
age of
Can
the
y'all hold it
case.
down, please?
Is due to it being a CODIS hit.
Right.
That's why you see the discrepancy in the offense stated.
So the main allegation in the motion to revoke in all three of these cases is that there is an allegation that Mr. Wilidge committed the new offense of burglary of a habitation, which was from August 29th of 2024. And what Ms. Malfino is reminding me of the age of that case, because it's old. I had wondered why, and that was because of a CODIS hit,
Right.
because of fingerprints potentially found inside that apartment. So I have, I'm taking judicial notice of the court's file. It does include that administrative hearing that the probation department sent over. As part of that, they do send what they have with regard to the new underlying offense. So I do have the report, or the investigation report, with regard to that burglary of a habitation from November of 2024. In addition, I've got the original pre-sentence report as well with regard to all three of the cases that he's on probation for. So, I keep getting that. Ms. Malfino, do you have any questions of Mr. Wilidge?
I do not, Judge, I would just ask the court also to take notice of our conversation. Thank you for taking that.
And I appreciate, I know there's a relationship potentially, but I've got some
No, I understand.
some big concerns. Mr. Wilidge, after he was placed on probation in 2020, had some issues in 2023 while he was on probation, and was given an opportunity to go to ISF. And that was at the end kind of 2023 is what my understanding is, which means, I don't know when you got out of ISF, but it had to be the very end of 2023, if not 2024. And then we've got this new offense alleged from August of 2024. Obviously, he hasn't been found guilty of that offense, but I've reviewed the report and the potential evidence that I've seen. I mean, the reason we got a CODIS hit is because of some fingerprints that were found inside of an apartment. And that, hold on, I was gonna look at something else. The underlying offense and all three of these are extremely concerning. The first two from December of 2017 are at a party and you got a gun and you end up getting into some issue with people and somebody gets shot with your gun. Whether it was intentional or not, you were intentionally at the party, you had the gun, you shouldn't have. And then the next year, I guess while that's pending, there's an aggravated robbery where you and some buddies go into a house to rob someone. Apparently it's the wrong apartment, but you'll still decide to rob him at gunpoint and pistol whip him. And you were given an opportunity on probation. Then you had some issues on probation and I sent you to ISF. Then you get a new felony offense of burglary of a habitation. So at some point, Mr. Wilidge, I've got to do what I can to keep people safe from you and your buddies and whoever else, whatever's going on, because you're not doing the right thing. And I appreciate that you have a family and your mom and your dad and people who are willing to help you, but they can only do so much if you're not going to do for yourself. And you have been a whole lot of opportunities. So based on that, because they're deferred probations, I'm going to grant the motion to set bonds in these cases, but I'm going to set bond in each case at $100,000. A condition of those bonds, if you make those bonds, are that you will be required, I need to know the address of where you will be living. It will either be with mom or dad, period. I need to know that because you will have a GPS monitoring device on that will require you also to be on house arrest at wherever that is, which means you cannot leave home except to come to court or visit with your attorney without my permission. So if you need to go to the doctor or if you need to do certain things, you're going to have to ask permission to go to those things before. Do you understand? Another condition is going to be that you would wear a drug patch at all times. And so if you make those bonds, you'll have to have a drug patch put on within 24 hours. Obviously, if it tests positive, those bonds will go back up, or I can find that you shouldn't even be entitled to a bond and you would have a no bond. Do you understand?
Yes, ma'am.
Okay. All right. You can go back with the bailiff. I'll reset it for an announcement.
Thank you, Judge.
Good morning. You're Jared Dobs.
Ma'am.
And Ms. Holmes, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Get this pulled up. Sorry, it's taking a minute.
Okay.
See, Mr. Dobbs, in cause number 25, DCCR 1492, you're charged with the state jail felony offense of theft of material, copper, from June 30th of 2025. Your indictment alleges you were previously convicted of the state jail felony offense of theft, March 28th of 2019, and after that was final, you were convicted of burglary of a building and state jail felony, August 11th of 2020. And how do you plead to that charge? And are those two prior convictions true? And did you enter your plea of guilty and true freely and voluntarily, and because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Dobbs is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time, find you guilty of theft of material, find those prior offenses true, sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification. That shows that this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right? Good luck to you, sir. You can go back with the bailiff.
Thank you.
All right, sir. Your Jetson bell.
Yes, ma'am.
This is cause numbers 25 DCCR 0108, 0109, and 0110. And Mr. Bell was set for trial over in drug court. There was a couple of issues with a video and also with obviously the jury. Have y'all been able to watch that video today?
All of them, yeah.
All right. And is there any change with regard to any plea negotiations or anything like that?
Not from our side, is that correct, Mr. Bell? Yes.
So you want me to put your case back on the trial docket? We'll get it tried as quickly as possible. Is that what you want, Mr. Bell?
Yes, ma'am.
And I do want to go back. It looks like the The last plea bargain rejection was in October. And it was so we've gone over this before. If you get found guilty and your prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years, up to 99 years or life. You recall that and you understand. And it looks like the offer then was for the minimum of 25. Is that still the offer?
Actually, we had come down from that, Judge, I think maybe before trial
Trial, yeah.
last time, and I think it was 15 years TDC or a cap of 20.
Okay. Well, at this point, you've seen everything. You still want to go forward with trial. There will not be any plea agreements accepted after today. Do you understand? And the only right way there would is if some new information came to light that your attorney or the district attorney did not have in their possession at this point. You understand? As far as you know, Mr. Smith, does Mr. West have all of the discovery at this point?
Except for the video copy that was made, I must have copied the wrong disc, but I will have this copied and it will be available this afternoon.
Okay.
upstairs.
And we've looked at all of it.
And you've been
But they
so,
have looked at
Yeah, we've
my
looked at
copy.
his copy, yes.
okay, sounds good. Then we'll get your case set on the next available trial docket. All right, you can go back with the bailiff.